Hey everyone, my name is Sean Shaw and welcome to Vanguards of Democracy. Thanks to those joining us via our radio show, podcast, or on YouTube. Longtime fans will be pleased to hear that we have decided to expand our audience in a way that will allow us to deliver high production content. This means that I'll still be holding live shows in the studio every other week, but on the alternating weeks, we will be airing pre-recorded episodes that will be broadcast on WTMP on Saturdays in our regular time slot. Our decision to pre-record episodes of Vanguards of Democracy brings with it the opportunity to film those episodes and air the audio from that recording. To see the video content that will accompany these episodes, we've created a new YouTube channel for our show where these episodes will be live after they have been broadcast on WTMP. I, along with my team, are excited to share the possibilities that open up for our show in the coming weeks. I hope you can find the time to tune in or look us up by searching Vanguards of Democracy. Thanks again for listening, but keep in mind this is a pre-recorded show, so we won't be able to take calls during this particular show, but when I'm in the studio, we will take them as we normally do. So next, I'll be looking at injuries and liabilities in youth athletics with the help of attorneys Brandon Cathey, Stephanie Miles, and Daniel Greene. All right, everybody, welcome to Vanguards of Democracy. This is our new format where we are going to play this live, and then we're also going to put it on the internet for you to see, so it's going to be fun. And so let us work through any glitches we might have. Be forgiving this first time, but we'll get better as we go. But I want to get into the first segment we're going to talk about, which is injuries to minors in athletics. And as school has started, and this is something that comes up a lot, but I want to introduce who we've got in the studio with us, and that's Danny, Stephanie, and Brandon. If you will kind of give a short introduction of yourselves, because I know people do it better than other folks. So tell us a little bit, and we'll get started.
Hi, I'm Daniel Greene. I'm an attorney here in Tampa at Swope, and I've been here 4 years now.
Hey, good afternoon. I'm Stephanie Miles. I'm a partner here at Swope. Been working here since I got out of law school clear back in 2005, and this summer, Danny, Brandon, and I tried a sports injury case over in DeLand, Florida. So it's a topic near and dear to our heart.
I'm Brandon Cathey. I'm also a partner here. I've been here since 2004. I'm the lead trial attorney here at Swope, and I get to look good because of the hard work that these two do.
Oh, nice. And listen, every sport has different types of risk involved. I was a basketball player, so that risk is certainly different than football, soccer, and all these other ones. And I remember when I was, it was a while ago, but when I was playing high school sports, I didn't care what the waiver said. Like, sign it, let's go. Trying to get on JV and varsity. It's up to your parents to make sure they know what's in that, but it's also up to the supervising adults and coaches who are employed with the school to make sure they're doing the right thing and make sure they're adhering to their duties. So what are options, first of all, for parents that don't want to sign a waiver? Now, when I say waiver, we all know what we're talking about, I hope. It is what you're required to sign so that your child can participate in high school athletics. And we're going to go over an example of what a waiver is and what's in it. But some parents may say, I don't want to sign the waiver. Do I have to sign it? What's the deal?
Well, it's an interesting question. In the world of law, we call these kind of contracts of adhesion. It's just a fancy word for, like, you don't have any choice. If you want to participate, you got to sign it. And it's, as technology has evolved, as word processors became a thing, and obviously now with the internet, it's just become common that we sign these kinds of things all the time. I mean, we click, we agree to get past go, all the time on the internet. And these sports releases are a similar kind of thing. It's like if you want your kid to be able to play the sport, the provider of this sport activity requires you sign their form. And so it's not a thing where you can negotiate it. That's what we call it, a contract of adhesion. And it's really something that we'd like to see more parents start to organize around a little bit to start giving some pushback on this. Because, one parent with one kid says, I don't want to sign it, and all the other parents do, it gives the activity provider the leverage to say, well, tough, then your kid can't play. But if a group of them all comes and says, look, we don't have a problem agreeing that if my kid gets injured due to the just inherent risks of the sport of, say, football, that no one's going to be responsible for that. But you're asking me to say that you're allowed to negligently injure my child? That should be something that all parents are pushing back on in an organized fashion to hopefully start making some difference in terms of the things that some of these activity providers are able to get away with.
But I mean, so if I understand what you're saying, short of kind of getting organized and pushing back in a way that is organized, you've got to sign the waiver if the activity provider says you got to sign the waiver, right? Like
if you
you've
want
got
to
to sign the
participate.
waiver if you want to participate in the sports. What about public versus private school? Is there any difference between what you said and if it applies in a private or public school setting?
Well, that's a really good question. It's something Danny Greene here is the kind of the foremost expert on. It depends on what kind of provider it is. Whether this is a commercial provider, a non-commercial provider, in terms of what they've got to have in the release. And Danny might be kind of the best guy to explain
That
the
was
difference.
a complicated answer. What's a commercial provider and a non-commercial provider and all that good stuff, Danny?
That's a great question, and that's going to really depend on a case-by-case basis. Florida courts have come forward and said that school activities, certainly public school activities, those are going to be non-commercial activity providers. Now, I don't want to go into a whole detailed explanation of Florida case law, but to quickly summarize, under Florida law, pre-injury releases that are signed by parents are invalid as a matter of law for commercial activity providers. Now, for non-commercial activity providers, they can be valid. So
what's a commercial activity provider?
That is not defined by Florida courts or Florida statute. Although the Florida statutes use that term, it's not defined. So
that's a very lawyer answer.
Yeah.
But it's not your fault.
The short answer
I wish they defined it, and Florida courts have actually written that they wish the legislatures would define it, and the legislature just hasn't.
Okay, well, I'm no longer in the legislature. So don't look at me.
The short answer, the way I kind of like to think of it, is if this is like an obvious business that's providing this as opposed to like a nonprofit or something like that, parent signs that release, it doesn't bar the kid's claim anyway. So feel free to sign it and don't even worry about it.
Let me give you a hypothetical as we do in law school. If it's a basketball camp, not associated with any kind of school, this is a all-star basketball camp and you sign a waiver. Is that a commercial activity or not? Or are you going to do like Danny and say, I don't know?
Who's running the camp, Sean?
Not a school, it's for money. It is a for-profit kind of entity that runs these camps.
A for-profit entity, that's going to be a commercial activity provider. Okay. And those releases are going to be invalid as a matter of Florida law unless they contain certain language, and there's a statute, 744.301, that outlines certain things that those commercial activity releases must contain. Now, if it contains that language, it releases the entity, the commercial activity provider, from the inherent risks of the activity. It doesn't release from negligence claims.
Right.
However, under the statute, there is a provision that says there's going to be a presumption if a parent signs that pre-injury release form that any injury that arises from the activity is from the inherent risk. And there's going to be a burden to prove that, no, this wasn't an inherent risk, this was actually due to the negligence of the activity provider.
So football is inherently dangerous, right? We all understand that. But I think what you're saying is if you get injured playing football, that's different if you get injured because the coach wasn't watching during drills and allowed certain contact to happen that should not be happening.
Precisely.
Right? That's the difference.
Precisely. So in that example, let's say it's a football camp run by a for-profit organization.
Or a former player. Or that would still be
or a former player for profit. In that situation, if a child's injured, if the parent signed a pre-injury release that contained that language, it's going to be presumed that that injury arose out of the inherent risk of football and not because the coach wasn't watching and the coach wasn't enforcing any rules. The burden is going to be on the injured player's parent in court to overcome what's called, remind me of the standard that was applied, that higher burden.
Clear and convincing?
Clear and convincing evidence. By clear and convincing evidence, which is a higher burden than normal, just greater weight of the evidence, that's applied in courts. By clear and convincing evidence, that parent of the injured player is going to have to prove that it was the negligence of the activity provider and not just an inherent risk.
Right, and so we're in my scenario where it's a football camp put on by a former player but kind of a for-profit enterprise. If you sign the waiver and your child gets hurt, right then it is assumed that that injury happened just because of the sport. It is then, now we start figuring out you probably need to get someone to investigate and a lawyer, and now you've got to start doing things to see if, was it really just inherently dangerous activity that they got hurt in, or was, there no supervision, or were they hitting too, then you've got to but you got to hire a lawyer and investigator and do some other things once that happens, right? That's
Absolutely.
Not like a parent can't on their own pretty much figure out how to get past that clear and convincing standard.
Precisely, and you got to scrutinize that release. You need a lawyer to look through the language, make sure it matches the statute. If it doesn't match the statute, et cetera, there's a lot of layers there to get to hopefully a recovery for a child that's injured in such a situation.
I'm sorry. We recently recovered $10 million for a young man who was hurt at a football camp. And in that case, we had to prove something beyond inherent, that the injury was something beyond what was inherent in the sport. And Stephanie was the one that figured it out, that there's this kind of concept that exists, for instance, in youth football, and it goes all the way up into the pro level too, that before a kid or any football player can start doing full contact football, they've got to go through this 5-day period, which they call acclimatization. It's a period of time for the kid to sort of get warmed up, get used to wearing the helmet, that kind of thing. But all these standards, all these regulations, they always talk about it as acclimatization, as though its sole purpose is to get the kids used to the heat of playing in the equipment. Stephanie figured out that it also had a secondary purpose, which was to integrate kids to contact. And she coined the term, really, contact integration. And in this last trial, we called it contact integration throughout the trial, to the point that even the head of the FHSAA that regulates all of Florida sports started using the term contact integration for this 5-year period. And this camp hadn't done that. They had done no contact integration period. And so that became the source for us to be able to say this injury wasn't inherent in the sport. The sport requires 5 days of integration. You didn't do it. So you're outside the bounds of football.
Right, and that's good lawyering.
That's good lawyering.
Good job, Stephanie.
I want to say, though, we kind of make it sound as if parents don't have any choice at all, right? You either sign the waiver, or your kids don't participate in fun activities, camps during summer. And, that's not necessarily true, right? Like, there's things parents can do to, figure out if a camp is safe. Talk to the camp director in advance. Kind of like what parents do, I would imagine, not being a parent myself, before they pick a school for their children, right? Like, you're going to reach out and figure out how the camp is run, ask the question. So if my son plays football, how is football going to proceed at this camp? Are there going to be drills? Is there going to be a contact integration period? Are they going to be acclimatized? And so, that's really the way that parents can feel good when they have to sign the release, of that.
That's important. That's a really good part, because what I'm thinking of, there are certain camps that are so important to your child getting to college to play D1 that parents think they got to go to that. Like, you got to go to the Nike or ABCD camp. You got to go to the McDonald's All-American. Like, you have to, but you don't. And you are still allowed to ask questions about even a well-established camp that you think is a feeder program to these big colleges. So you have a son or a daughter that's an amazing athlete, and you want them to go to this camp so they can get seen by coaches, and you think they got to go to this camp. You still have the ability, to your point, to ask, what's going on? What are the drills, and who's watching, and how many coaches are you get to ask all those sorts of questions until you get comfortable. And if you're not comfortable, it's more important to feel good about the safety of your child than to think they're going to go to the Nick Saban football camp. It's just more important, to your point.
Yeah, that's definitely true. I mean, you've got to put trust in these places that are putting on camps on the one hand, but on the other hand, make yourself feel good about sending your kid off to camp for a week.
Right. Let's talk about now in a school setting. We talked about the for-profit a little bit. I want to talk about in a high school setting, when you sign the waiver to allow your child to play whatever they're going to play. It is the standard, I think, is different, right? That the waiver is.
Sure. So the FHSAA has a waiver form,
which is the umbrella athletic organization for high school sports, right?
Sorry, the Florida High School Athletic Association, FHSAA for short, which is the organization that runs high school athletics in Florida. They have a standard form that has to be signed before all athletics, football, basketball, everything. And that form has been held valid to prohibit claims against the school, the coaches, etc., the school board, the city, for claims against those entities. It has been held valid. So in that situation, children actually are not allowed to play high school athletics unless they sign this FHSAA form.
And that's private and public, correct?
For any FHSAA member school.
Right.
Which includes public and private schools. Not every private school, but certainly most in the state of Florida.
And so essentially what you're saying is that you have to sign that. And does that waiver include everything?
That includes negligence claims. Okay. Now, The one thing I will say is that there is a divide within the courts themselves as to whether that is valid. So while there are cases saying, yes, that FHSAA form is valid, it bans all these negligence claims, there are also dissents in those cases that say, not so fast. This release, it's not very clear. I don't think it should release these negligence claims. Parents don't realize what they're doing when they sign these, that they're allowing cities, schools, coaches to negligently injure their children. So even within the court system, there's a split. So that's something, if there's a situation, again, where you have a child participating in an FHSAA sanctioned event, and the FHA, after they're injured, says, hey, here's our release, that's something where you're going to need a lawyer to come in and say, whoa, not so fast. This release isn't valid. Yeah, there are cases saying that it is, but there are arguments, certainly arguments to be made that those waiver forms are actually invalid under Florida law.
That's a lot to be able to waive negligence in that context to allow a child to play an FHSAA sanctioned sport. Wow.
Precisely, and there's public policy arguments against it as well, which seems to be what you're alluding to, to say that in order to participate in Florida high school sports, you have to allow those entities to be able to negligently injure your children with no recourse. So.
Right, particularly given, just the place that sports plays in our school activities, like that's the majority of the children play some kind of sport, I would think.
Absolutely.
Wow, that's a lot. All right, we've got a waiver form in front of us, and it's short. And so I want to kind of go through it a little bit, maybe 5 minutes of just going through it and kind of, in a non-lawyerly legalese way that we are probably prone to do, explain what the clauses generally mean so that parents listening can kind of understand. So I don't know which one of you want to start, but kind of just start from the beginning, and let's see what's contained.
So this first clause, and Brandon, I'll end this way so you can see it as well. This is this form that the parent has to sign. I am not aware of any injury, illness, or other health-related issues that would restrict or limit my child's ability to play competitive sports. Now, that clause in and of itself, it doesn't contain any release language. That's not releasing any entity from a potential negligence claim, but that is making a representation to the activity provider that this child does not suffer from a heart condition or some sort of cardiovascular condition that's going to prevent them from participating in the sport, where if it turns out, in fact, that the child did have a cardiovascular condition, heart condition, something that affected their ability to play in the competitive sport that's mentioned here, that could be a misrepresentation on the part of the parent if they knew about that, and that could come back.
And this is, I should have said that this is not an FHSAA.
Yes, this is not an FHSAA form.
As we just said, you got to sign that, and you're waiving away anything anyway, so we're not going to go over that. We're going over kind of one that might be used in the for-profit type of setting.
So that first clause, that doesn't contain any release, but you also, as a parent, you don't want to be misrepresenting anything that you're signing.
Let's stop here, because that's important. These waivers are extremely important on both sides, on what the provider is essentially saying and what also you're saying as a parent. And you may feel that it's, you're just signing a waiver and I don't know, and these things are extremely important in what the representations you're making. If you make a false representation on purpose, or if you make a false representation just by, I didn't remember, I didn't do due diligence, what can happen as a result?
It could certainly affect any claim in the unfortunate event that you do have a child that's injured after signing this form, and you bring a claim as a result. The activity provider is going to assert as a defense, hey, you misrepresented to us that your child was able to play in this sport, and as a result, you can't bring the claim because the reason that your child got hurt here isn't because of anything we did wrong. It's because he had a cardiovascular condition.
I mean, this is probably the plainest one that you can draw a line from point A to point B. Your child has a heart condition. You put on the waiver, my child does not have a heart condition. They have a cardiac incident while they're playing football, and you want to bring a claim. Well,
Precisely.
You're going to probably not be able to bring a claim because you didn't list that condition on the waiver.
And you made a representation to the activity provider that your child did not. have that
Right.
condition.
It's important. I'm sorry.
It's never that clear cut though, right?
Right.
Like,
And that's why you have lawyers, because it's never that easy.
Yeah, say your kid has asthma, but you send them to like badminton camp that's in an
Right.
air-conditioned gym. You don't think that the asthma is a health-related issue that would restrict my child's ability to play badminton in an air-conditioned gym.
We're all
So,
lawyers there. What about COVID?
You know,
What about COVID? If my child has COVID, is that something that I need to worry about as it relates to sports? And this waiver language that we just saw?
I mean, if you're a parent, you probably don't think that your child having COVID is going to affect their ability to play a sport at the time that they're going to attend this camp if they had COVID 6 months ago. I mean, I don't think that's reasonable for a parent to have to draw that kind of timeline.
Right.
I mean, that doesn't mean the place that's put on the camp isn't going to jam that down their throat.
Right. No, that's I want to bring that up. Okay, go on. See if we got some other clauses here.
We got a pop up.
We're having a hiccup over
We're having
here
some
on
iPad
our
difficulties, but it's all
Yeah.
good. That's
So the next clause, I agree to assume all risks and expenses due to an injury that may occur as a result of my child's involvement in competitive sports practices, games, and or travel to and from said activities.
no, that is a lot of gobbledygook. What does that mean?
So that is what I would term as an assumption of the risk clause. And there's certainly a lot of nuances to that. And again, this is something where, you're going to have lawyers who are going to spend time researching this clause in the case law. Has something like this ever similarly come up? But again, this is something that a lawyer is going to delve into for hours.
Right.
What does that clause mean?
Right.
And there's going to be a fight between, of course, the parents bringing the claim and the activity provider as to what exactly that clause means.
Lawyers spend a lot of time fighting on compound sentences. I hear you.
Yeah, if an injured child's parent has signed that clause, I'm not concerned. Right? There's nothing in there that suggests that they're waiving or assuming any of the risks that an activity provider negligently injure their child. It's just due to injury.
And we're gonna, before we go, I want you all to give examples of negligence. And I don't want you to give any identifying information, but I want you to, because we're all using the term negligence like we know what it means in a legal sense, but I want it in a real world. What's an injury caused by negligence? But let's keep going through this a little bit and we'll get there.
So this last clause, I agree to hold the school or anyone acting on its behalf, either as a coach, coaching assistant, administrator, harmless in the event of an injury to my child while participating under the supervision of the above. Now, this is what is known as a hold harmless clause, and I'll let Brandon kind of speak to that.
Well, yeah, hold harmless clauses are kind of an old-fashioned thing that has been in contracts and things for a long time. And I think, as far as hold harmless clauses, this would be a little more difficult than the previous clause. But I think we'd have the same issue here. Like the courts, when they look at these, they want to see that the parents are signing something that indicates they understand that the people supervising their child could do something wrong, and that they're even giving up those kinds of claims. Not just that they're agreeing that if something happens that's part of the usual injuries related to the sport. And so I think we would be okay on that one too. There's nothing about negligence. There's nothing indicating that this would include errors made in supervision or anything even like that. But hold harmless generally means that if they're responsible, if in this case, what is it, someone acting on behalf of the coach, coaching assistant, or administrator, that if they come to be responsible to someone else for injuries to this child, that the parent's going to reimburse them. That's basically what it amounts to. So maybe a coach ends up, paying a medical bill or something for the kid because the parent's not around. They'd reimburse them. That's what we'd be arguing that is as much as that clause could really cover.
I got you. Oh, is that it?
That's
Yes.
it.
And
These are short.
These
These are short things, but they're super important, and that's what we wanted to do this segment as school starts and kids are getting involved in this, because your kid's going to come and say, look, I'm trying to play basketball and or football, and they're going to want to play, and you want them to play, and you need to understand the risks associated. But let's talk about negligence for a little bit. Give some examples of injuries that are caused by negligence that aren't just inherently I tore my ACL playing soccer, or I sprained my ankle playing basketball, or maybe I got a concussion playing football or something. But what are some injuries that are the next level that are negligently caused?
Well, they're going to be usually sports specific. The legal standard for negligence is what would a reasonably careful person do under the similar circumstances. And so a big area where a lot of injuries occur, for instance, is in cheerleading, right? And so the way a reasonably careful coach would coach kids doing cheerleading, perhaps, to do, when they're doing aerobatics, they're flying through the air, would be that they would have spotters to make sure that they catch him should they not come down feet first. And so something that would be negligent, which we would say is not consistent with what a reasonably careful person would do, would be to let them do it without any spotters, right? That's just not what people who coach cheerleading permit, right? And then football, you can have the same thing. Like if you said, we're going to let these kids play tackle football, but they're not going to have to wear helmets and shoulder pads. They're just going to go out there rugby style and play. And you say, that's not what reasonably careful football coaches permit. That's negligence. Those are kind of some examples in the sports setting. People are more probably familiar with it in the automobile setting, right? Like reasonably careful people don't run red lights, right? People don't drive 25 miles over the speed limit in a school zone. Things like that are negligent because they're just not what reasonably careful people do under those circumstances.
And I just want to make sure our listeners and viewers understand, negligence is the next level of what happens in the ordinary course of business. It is not, in this setting, it's not the injuries that just happen because of the inherent nature of the sport. It's the next level type of deal, and that is what is implicated in these waivers, is what we've been trying to talk about.
That's right. If you were doing this the way you were supposed to be doing it and a kid got hurt, you're not responsible because you weren't negligent. But you were doing it in a way that no one really would ever say was okay, and that's why this injury occurred, like no spotters or something like that.
And quite frankly, you should be responsible if you're not doing it safely.
Correct.
And it's not just ambulance chasing lawyers, and it's not just greedy people. You should be, if my kid is in your camp, and you are not being safe with how you're conducting the camp, and he gets hurt or she gets hurt, yeah, that's a problem. And this is why we have a court system set up to determine that, and that's why we're talking about it today.
Yeah, negligence is really just about, who should be responsible for the expense that was incurred. I give the example of, I'm negligent all the time, right? Like I'm out in my yard and I've got the ladder set up and I'm working on hanging Christmas lights, and up on the top of the ladder I've got a helmet and a drill and all these things sitting up there. And I decide, I want to move this ladder over without bringing those things down with me. I decide I'm going to just try to, carry this ladder precariously holding all these tools up there on the top, and one of them falls off and hits me on the head. I'm responsible for my own damages, right? But by the same token, if I asked a kid, I said, would you take that ladder, knowing all that stuff's up there, and carry that across the yard and something fell on his head and hit it, I'd be responsible for that too, right?
No, that you should be.
It's like, can you plan for it and can you prevent against it?
That's
right?
a good,
really real easy questions for parents to ask themselves. Like, is it negligence? Could this school have planned, knowing it was going to happen in this setting, and could they have done something to prevent it or minimize the risk?
Right.
And
go ahead. Sorry.
I was just going to add one thing. And just because it sounds like an injury that is an inherent risk of the activity doesn't necessarily mean it wasn't due to negligence. I'll use the concussion example that you used, Sean. Just because if your kid gets concussed playing football, at first blush that may seem, concussions, those are inherent risk of football. Everybody knows that. But if you do a little digging and you find out that these kids, they were playing contact football for 3 hours a day on back-to-back days, you find out, oh, wow, you're only supposed to play contact football for an hour and a half a day, and you're not supposed to do it on consecutive days. And my kid got hurt on the third day of playing contact football over and over again. All of a sudden, this concussion isn't an inherent risk of the activity. It's as a result of negligence from the coaches who are sending these kids out there playing contact football over and over.
That's a great point. I want to ask two questions. One, because you talked about hours and consecutive days, are there rules of what is allowed to be done in these various sports settings? And if there are, where can parents maybe find those? Like, how do you know how much contact a child is allowed to have in a certain sport, or how it's supposed to be conducted?
So there are rules or guidelines, I should say, that govern, for example, Florida high school football under the FHSAA. FHSAA has a rule book, and they provide this is how much contact football you're allowed to have per week, per day. They define levels of contact from air, where you're just doing air drills, to bags, where players are hitting bags all the way down. Thud, which is supposed to be not all the way going to the ground, and live contact, where full-on contact football. And there's limitations on all those. And that's all found in the
And that's all,
FHSAA.
I bet that's online.
That's all
on
online.
their
You
website.
Google FHSAA football guidelines.
And we're getting to the end here, but I want to ask this. A child gets hurt doing the activity. What's a parent do right then? Like what is the train of thought as to whether this is inherent or not, or I want someone to look at the waiver, like how does a parent conduct themselves? Kids hurt right during an activity. What's the next thing they ought to do, and maybe on down the line?
The first thing to do is just focus on the health of the kid,
Right.
right? Don't worry about the lawsuit. Don't even be thinking about that, right? That's what lawyers are for. And just take care of the kid and make sure the kid is safe. The second thing is, of course, just to try to gather the facts, and that's a really important one. You know, coaches and adults who are responsible for supervising kids will sometimes do negligent things. And, you know, negligence, as we've given some examples, doesn't mean they did it on purpose. But a lot of times coaches and other supervisors will kind of understand that they're responsible, you know, that they made a mistake. And they don't necessarily give the full picture of what happened. A lot of times they give parents a little bit of an inaccurate view to kind of cover up maybe some things that they did wrong. And so I would say the second step is to just kind of do your own investigation. Talk to other kids about what they saw. Thoroughly ask your own kid questions. You know, try to figure out what the real story was about what happened at that caused their injury, just for peace of mind. And, you know, 99% of the time, you're probably going to find out, right, that nobody did anything wrong. They were all doing their best, right? Coaches are some of the greatest people there are, right? These are people who are sacrificing their own life to give it to kids that aren't even theirs, right? To help grow them into better people, to help give them lessons on being teammates and how to work together and how to work hard, how to accomplish goals. I mean, it's hard to find a way to criticize a coach, right? But that doesn't mean that they're not human. Sometimes they do make mistakes. And almost every single time that there's a mistake made, there is an insurance company that has been paid to insure this risk. So if there is a kid that is hurt, there's insurance money available specifically for this. And a lot of times parents are made to sort of feel guilty, like, well, you shouldn't be questioning the coach. You shouldn't be questioning after all he's done for your child. It's not about that, right? It's a coach can make a mistake and they have insurance for this. And the only person that benefits when you don't ask questions is the insurance company.
Mm-hmm. Yeah, the school's covered, but
right.
For the most part.
I would add a third thing for parents to do that I think is probably hard after their child suffers a horrendous injury, is to exercise some self-restraint in what you say about it and to who.
That's true.
You know, as parents are coping, and we live in a world of social media, it could be easy to either like take the blame on yourself or to quickly want to blame others. And I think it's important not to do that,
right.
To just try to stay the course, focusing on the health of your child, doing your own investigation at the same time, but not saying much about it.
That's a really good point. All right, I appreciate y'all giving us some tips here. We're near the end, and we are all, as a side note, we're all in a fantasy football league together. Who are your top running backs you're targeting this year? I'm kidding. We're not going to do that. We're not going to do that.
Oh, here I was ready to
We're
go.
not going to do yeah, because I know you're going to lie, so that's why we're not going to do this on TV. So, no, I appreciate it. Thank you. It's an honor to work with three stellar lawyers such as yourselves. I'm always amazed by how good you are and what you're doing for people that need you in their time of hurt and time of most vulnerable, being the most vulnerable. So I appreciate it. Thank you for coming on to our first taped segment. So we appreciate that.
So happy to be here for the maiden voyage.
Yeah.
No, I think we did pretty good. So I appreciate
Thanks,
y'all
Sean.
coming on. Thank you. All right, we are here with our next segment with a good friend of mine, and that is Dale Swope. And if you're in the legal community in Tampa, you know who Dale is. If you grew up in Tampa, you know who Dale is. If you want to do a historical tour of Tampa, you know who Dale is. But Dale's a great friend of mine. He's a great person. Actually, one of the jobs I interviewed for when I moved to Tampa was here at the law firm, and I ended up going somewhere else. But the world is weird, and here we are, full circle back. Dale, it's good to have you here, man.
Thank you, sir. Good to be on board.
I want to talk about DeSantis as usual because he's so infuriating. But I want to talk about it from this legal perspective because you're on here and you're a damn good lawyer, as we all know. And DeSantis, they tell me he went to Harvard Law School, but I've been telling people the first day I was in law school at the University of Florida, I knew all this stuff was unconstitutional. So I don't know what he's going. He does too.
He does too. I mean, he did go to Harvard Law School, and Harvard Law School, has no room for people who aren't highly intelligent. So it's a little more troublesome whenever you have somebody is intelligent, knows better, and he does it anyway.
That's a very good point.
I mean, we can't give him an excuse. You can't just say bless his heart, he doesn't know better, because he does. And
well,
dangerous.
And so I want to talk about the lawsuit with regard to the mask mandate. So I've talked about this on 3 or 4 shows because the issue has kind of progressed. And here we are to the latest episode of it, which is almost the most sad, the most obnoxious. So the timeline of it is, of course, our governor doesn't encourage people to get vaccines. He kind of encourages you to do other stuff. He's all about freedom, so he says. He doesn't believe in masks, and he certainly doesn't believe in mask mandates and in the school system particularly. So there's been a big fight. He passed an executive order that prohibited school districts from having a mask mandate. Let me repeat that. The governor says that a school district with its elected school board members cannot make the decision about whether schools in their district will have a mask mandate. He prohibited it. There are certainly school boards around the state then began to, and I'm going to use this word, defect. And what I mean is there were school boards that started saying, you know what, we don't care what that executive order says. We are going to enforce a mask mandate, and you're just going to have to deal with it because we believe that we are the people that ought to be deciding what happens in our schools, not the governor. The governor and the former Speaker of the House, our one-time buddy Richard Corcoran, then said, well, if you're going to have a mask mandate, we are going to withhold the salaries of any school board that allows a mask mandate. Withhold it. If that's not petty, Dale, I don't know what is.
Well, look, I mean, you have to take this, you have to break it down at 2 levels. You have to first say, is this good policy? Should we have our children wearing masks to protect not only themselves? You know, when we say that a child has to wear a mask and they say, well, this should be parents' rights to determine that, that's as if the mask was intended to protect that child.
Bingo.
If my child wears a mask, it's not because that's to protect my child. That is to protect all of his classmates, many of whom may not be as healthy as he or she is to protect their teachers, many of whom may be elderly or have vulnerabilities. That mask is not a matter of personal choice. It's a matter of social responsibility. And our government has always taken the lead to enforce for public health. When I was a child, we were given a polio vaccine in school, and I don't remember anybody really asking me my opinion on whether I wanted it or not, because it wasn't just to protect me from polio. It was to eradicate polio from the face of the earth. Same for measles, same for diphtheria, same for various other childhood diseases that used to kill thousands of children a year, and they're gone because public health officials were presumed to have a right to come in and take actions and impose mandates for the public good, not for an individual good. And I think that this mask is such a tempest in a teapot. This is nothing more than politics, where it's become a statement of, do you believe in personal freedom? Because by God, if you wear a mask, you're a sheep. It's not about you. It's about the germs. This Delta variant has 1,000 times the viral load that the original COVID did. It is incredibly more infectious, and it's deadly. It's at the stage now where pretty much all of us know somebody who has died from the Delta variant. I saw today the husband of a woman who used to work in our firm, 40 years old, 2 children, needlessly died because not vaccinated, and people around him weren't being careful, I suppose. Whatever the reasons, it is the government's job. But that's the policy question. Like, is this a good idea or not? There's a second level of this, which is, do we live in a dictatorship where one person dictates all of government what they should do, or do we live in a more representative democracy where there are various levels of government? That is what America is structured by a written constitution that establishes various levels of government. Our governor, I believe it was probably Governor Scott, who is the first one who came in and thought he had been elected as the CEO of the state. And he had quite a big awakening when he found out that he can't just do what he wants. He can't just issue dictates the way that Mussolini may have, when he became dictator. That's not how our government works. We have federal government, we have state government, and we have local government. And local government has local officials who are elected locally, and they make local decisions. And that's what school boards do. School boards aren't just some kind of a JV team for future political aspirations. School boards have power. And school boards have power to make decisions about how the schools are run in a local place. We've established our Constitution that way for a good reason. The school in Miami-Dade shouldn't be run the same way that a school in, I'm going to say, Liberty County is run. The mask mandate, if you live in Hillsborough County, where the school's one of the largest school districts in the nation, schools are crowded, schools are packed in. We're bussing kids in from all different neighborhoods who may see each other for 7-8 hours a day, jammed into classrooms that don't have the right filters and so on to be able to control this. The people who are in Hillsborough County responsible for those schools would probably make different decisions than those who are up in Columbia County. Those kids, they're on tractors, they live on farms, they live apart from each other, they're not packed in. They don't have nearly the same number of school kids in their schools. If a school district in Columbia County votes that they don't think that mask mandates are required because they don't have really any COVID in their county, well, that's one thing. It doesn't necessarily mean that it ought to apply to those who live in the intensely packed-in counties. And so that is the most dangerous part. The question of whether we require kids, whether kids ought to wear masks in school or not, that's a question of whether you're going to unnecessarily kill or hospitalize a few dozen people. Believe it or not, this other question is more important. The question of whether we're going to have elected officials be able to do their job without this heavy-handed, overpowering dictatorship who comes in and says, we'll order you not to do your job, and if you vote the way your conscience tells you to vote, by God, there will be sanctions. There will be consequences if you do that, and then impose it at the petty level of saying, we're going to hold up your paycheck. Well, these people are being paid, $15,000 a year? Yeah. It's volunteer service. It's just it's an insult to say that somehow is going to change what they believe in their heart. And B, it's very dangerous because you go down that path, there's no coming back.
And if the way America works, if you don't like something that an elected official does, you vote them out next time you get a chance. You don't get
we intend to.
Right, which I hope is coming soon.
Yeah,
but
man.
You don't get to do exactly what you're saying. DeSantis doesn't get to be in charge of everything. We have school board members, and we have county commissioners, and we have city council people, and we have superintendents, and we have all these levels that are all elected just like him.
And this isn't because we like inefficient government. Somebody may say, man, you guys have so many layers of government and so many people and they could override. It is because we understand that consolidated power is dangerous. Absolute power corrupts. Absolutely.
That's why we're set up like this.
It is exactly why we're set. Which takes you to the next stage, which is we have consciously built in a separation of powers. We have 3 branches of government. We have a legislative branch, which is our House and our Senate. We have the executive branch, which is the governor. And then kind of above everything else, we have the judiciary. The judiciary are intended to be non-political judges who have training, who are elected because of their wisdom and their demonstrated understanding of the law. They are supposed to be making decisions. They're not facing election every 2 years. They are making decisions based on precedent, based on how the law is and what it has been. The legislature makes the law, but our judges understand how to apply it. And more importantly, they're the ones who understand that there are limits on legislative power. The Constitution overrides it all. And what's happened now is we have this governor and his appointees who, in the face of a judicial order, they had their day in court. They came in, their lawyers came in, everybody put on their evidence, everybody made their argument, and an impartial judge sat and heard the case and he decided against them. Now, every lawyer has had that happen. If you've never lost a case, you just hadn't tried enough of them. And when that happens and a judge rules against you, your respect for the judiciary and for the Constitution requires you to accept that. You can appeal it. That is a process where you appeal it to the next level. And if you want to, there's one more level. There's 2 levels of appeal. But you don't walk out of there and ignore it. That is something that we disbar lawyers for. And in fact, we throw people in jail and contempt orders for that. Whenever a judge has made a final ruling and said, here's how it is, your remedy is to appeal it. You do not have, nobody is above the law to have the right to just purposely disregard it. And that just happened.
Well, that's what I want to set up a little bit. Everyone went to court on this mask mandate.
Yeah.
The judge ruled you cannot prohibit school boards from issuing mandates. Right. The judge said that. Within 24 hours, Commissioner of Education sent letters to Alachua and Miami-Dade County that said, tell us the salaries of your school board members because we're docking your budget that amount. Which means just what you said. After the judge said you couldn't do something, they immediately went and did it. You cannot do that. It's not only unethical, it's illegal, it's all the things that you just said. We throw people in jail and contempt for that. You can't, and everybody involved is a lawyer. The governor's a lawyer, Corcoran's a lawyer. Everyone knows you shouldn't be doing that. The absurdity and the obnoxiousness of doing that is what I think you're talking about. What kind of state do we live in?
Well, and look, at some level, these guys are all people too, okay? Mm-hmm. They are smart. They're Americans, and they believe in our country, and they're patriotic. I do believe that in my heart, and I believe that they're lovers of democracy the same as we are. And how could this happen? And I think that this has become such an emotional topic. It has gotten people wrapped up, and they're doing things that they'll look back on in a few years, and they'll write a book that says that I made a mistake.
In the meantime, we're right here.
In the meantime, they have taken us to the precipice of a very dangerous condition. You know, we saw this at the national level. We saw lawyers promoting in court this idea.
This is why you have an insurrection. This is why people think it's okay to storm the Capitol.
Right.
Elected officials acting like this.
Look, it's a pretty damn thin veneer that separates our society from chaos. What we think of as durable, we think that, we see what's happening in Europe and democracies are falling apart, or this is happening over in Southeast Asia or happening in Africa. Could never happen in America. America's institutions are too strong. You're nuts. It is a very brittle veneer that separates us from the loss of our democracy. The only thing that makes people follow the law is because everybody follows the law.
Bush v. Gore.
Bush v. Gore.
The Supreme Court of the United States ruled that Bush was the president.
Yeah.
And we all just kind of followed that because that's how the country is.
It was such a bitter loss.
It was a bitter loss, but we all accepted when the United States Supreme Court says something, that's it. In other countries, that doesn't happen.
No.
Who cares what the court says?
It is exactly
You come
true.
to the presidential palace and kick me out, then. That's how other countries work.
You know, Adolf Hitler was famous for a quote one time whenever the courts told him he couldn't do what he wanted to do. And he says, here's what we'll do. Let's fight about it. You stand over there with your law books. I'll stand over here with my guns. And let's see who wins. The judiciary depends on the executive to be able to effect its rulings.
Bingo.
And if the legislature is unwilling and refuses to do that, then you don't have a functioning democracy anymore. The judiciary doesn't have an army. They have bailiffs, right? They don't have the power. They don't even have the power to levy taxes, to be able to hire staff, and to buy a building. They depend on the legislature and the executive, and that depends on their patriotism. That depends on the people in those positions to say, I love the country more than I love my own ambition, and I am going to honor what the courts have said. If people begin dishonoring what the courts have said, don't be shocked when nobody honors it.
Bingo.
Don't be shocked when nobody's following the law. Don't act surprised whenever your followers are now thinking that it's okay for them to have an armed insurrection against the very heart of our democracy.
It's just
We were within 24 hours of losing our democracy following this election. I mean, we were not equipped. When somebody takes over the Capitol, now all of a sudden you'd be shocked. People start giving orders from the White House to the military. Military is in a quandary. Whose order do we follow? And so it becomes it's happened before in other places. Yeah, we shouldn't think that it can't happen here. It depends on our love.
It depends on, and we have to, I've said this before, all of us, even if we're Democrats or Republicans, we all have to believe somebody, right? Like you can't just believe your folks and no one else. When half the country doesn't believe the CDC,
yeah,
that's a scary place to be. When half the country doesn't believe the leading doctors and scientists that say XYZ about COVID and how to stop it and what to do, just because they have essentially believe only politics and nothing else, that's a scary, scary place to be, coupled with, I don't have to do what a judge says, coupled with, well, January 6th almost, we're in a much more delicate place, Dale, I think, to your point, than I think people realize. And I don't want to sound alarmist, man, but like, I don't think the country passed a test on January 6th. I think it showed we're in much worse shape.
The fact that it happened, the fact that it could ever happen. Okay, I'm an old man. It's never happened before in my lifetime. Never happened in my father's lifetime. And I can tell you it never happened in my grandfather's lifetime. So I don't know why anybody wants to say that demonstrates some kind of a success for anything. We should never be here. It is up to our elected officials to tone this down. It is up to our elected officials. When we lost Bush v. Gore, many of us felt like that was an unjust outcome. The Supreme Court issued a hundreds of page opinion in 3 days. Clearly that was a preset decision that they had already made their minds up. And that stuck in everybody's craw. But you know what? Nobody stormed the Capitol. Nobody suggested that was the courts ruled. And
Gore didn't say it was a lie.
Gore didn't
say it was stolen from him.
Spend the next 4 years continuing to complain about how the process was stacked against him. I mean, we all understood that
he immediately came out and gave a great concession speech, and the country benefited from it.
We all moved forward. We moved forward for better or for worse. We got ourselves into war in the Middle East. It never seems to end. For better or for worse, we moved forward from it, but we didn't have this questioning of the fundamentals of democracy. And you didn't have elected officials who flagrantly violated court's orders. The last time I remember hearing about that was George Wallace in Alabama, whenever the Supreme Court said, you got to desegregate your schools. And he stood in the doorway of the University of Alabama and he wouldn't let students walk in who were black. It's the last time I remember a public official flagrantly violating a court's order, but that really was just for show. He did that for about 15 minutes. The TV cameras turned off. He got out of the way, and the students went on in. This is for real. This is for real. And like I say, I don't think these are evil people. I think that the day will come they will look back on this and say, I don't know why we did it. And I can tell you, I think that temperatures and emotions have amped up. We're in the middle of a worldwide pandemic. It shouldn't surprise anybody that people are acting a little bit out of character for themselves. And all of us got to show our leadership to get back into ourselves and get back into character.
I'm going to end it there because that's a good, hopeful note, because I want to end it on a more disappointing note, but I'm not going to do it. I appreciate that, Dale, being hopeful at the end. And you're right. I've said this before on probably my last show. It's up to what our elected leaders say is important, and the image they project is important. And whether they're optimists or pessimists or they want chaos, it matters because people are going to follow them. But, man, I appreciate it. I think you're going to be a regular on here. And now that we've got this video going along, I think I'm going to be able to get you on here a little bit more so you can be on the podcast. We appreciate you being on here. We'll see you next time.
Everybody likes talking to the fat, bald-headed man. That's for sure. So I'll be here. All right.
We appreciate it. Thank you.
Thank you, John.
Vanguards of Democracy is brought to you by Vanguard Attorneys, a Florida personal injury law firm located in Ybor City that's been in practice over 10 years. The Vanguard Attorneys team is led by myself, Senator Arthenia Joyner, Carissa Perez-Illick, and Sylvia Brett. If you've been injured and want to make sure you get the best recovery possible, call Vanguard Attorneys. Naturally, you never pay a dime unless you win, but you can get that from any attorney. What makes Vanguard different is our intense commitment to getting you justice and getting it fast. If you've been in an accident, call us at Vanguard Attorneys at 813-471-4444. We hope that you will call us for a free consultation. You can listen live on WTMP 1150 AM in Hillsborough and 97.5 FM in Pinellas, live on WTMP, and also on AM 1150 WTMP.com or your computer, or download the WTMP app or the TuneIn app on your cell phone. You can watch this episode live on YouTube. Just search for Vanguards of Democracy.